Three Zimbabwean-born law graduates who cannot practice their trade because they are not permanent residents or citizens of South Africa have launched a constitutional challenge to the Legal Practice Act. In pending litigation before the Pretoria High Court, Bruce Chakanyuka, Nyasha James Nyamugure and Dennis Tatenda Chadya say they have all got the relevant degrees, have written the board exams and done their pupilage. They also have all various permits which allow them to live, study and work in South Africa. Muchengeti Hwacha is the Executive Director, Asylum Seeker, Refugee and Migrant Coalition, and joins us now. Very good evening to you. Thank you so much for speaking to us. So if you could please just outline to us the Constitutional Court challenge, what legal precepts were used to prevent the three from practicing law in this country?
Good evening, and thank you for this opportunity to speak on this very important issue. In essence, the Legal Practice Act, which regulates the legal profession, requires these individuals to be permanent residents in the country. They still have the right to work on the basis of the visa that they have. And essentially, we are trying to use the equality jurisprudence of the country to allow these people to practice their trade.
So we'll get into the minutiae of all three and how they came about to get papers to study. But what would it take ultimately to overturn this contentious section of the LPA by the Asylum Seeker, Refugee and Migrant Coalition, just in terms of combating discrimination against non-citizens?
We think it's a very straightforward case. The court has already has a lot of jurisprudence on the right to equality, and we're just trying to take that and apply that to these non-citizens who are attempting to practice their trade in this country. Many other cases have been decided on similar merits, and we just want those same precedents to be applied to these non-citizens to cure this discrimination.
But what specifically is discriminatory in legal terms in the provisions of the Act?
Well, whenever the state limits the rights of any individual, there needs to be a rational basis for that limitation. And our contention is that there is no rational basis for the limiting of the rights of these applicants. And we essentially are going to ask the Minister of Justice and the Legal Practice Council to show to the court why there is a rational basis for that discrimination. And our contention is that there isn't a rational reason for discriminating against these individuals.
Okay, so just so that we can make it as accessible and understanding as possible, Mr. Chakanyuka, for instance, says the permanent resident requirement is an absolute and inflexible barrier. Can you expand on this? Is this what you're pointing to?
Yes, so one of the tenets of law is that wherever we have a law, it must allow flexibility for various circumstances that arise. And in this case, there is an inflexible bar to these individuals. If I may make the example of the private security industry, it too requires permanent residence for individuals to be licensed to practice in the private security industry. However, there is a simple exemption mechanism that allows people in the position of Mr. Chakanyuka to practice their trade if he was in the private security industry. And so we're just saying that the court must simply allow some sort of exemption to allow these individuals in these unique circumstances to practice their trade.
So what reasons were given to Mr. Chakanyuka? I believe that he obtained the Zimbabwean special permit to live and work in South Africa. He graduated, he passed his bar exams, but he was denied admission for the Legal Practice Council. Just what were the exact reasons in his case?
The reasons given, not to Mr. Chakanyuka specifically, but to the broad range of applicants in his position, is that the current legislative framework requires one to be a permanent resident, which is an immigration status that is conferred upon one in terms of the Immigration Act from the Department of Home Affairs. And we're essentially saying that where Mr. Chakanyuka already has the right to live and work in this country, there shouldn't be a bar on him practicing his profession to the fullest.
So in the case of Mr. Nyamugure, he has a master's in law from the University of Stellenbosch. He's written his exams and completed his articles, all the requirements needed to be admitted as an attorney if he were South African. So he then applies for permanent residence, but is then turned down by the Department of Home Affairs. Was there a reason cited there?
The reason why is that in 2014, the Department of Home Affairs specifically implemented a policy to refuse permanent residence to individuals who would like to become legal practitioners. And essentially, we are saying that that policy and its application is unfair on these individuals who, as I state again, have been granted the right to work by the Department of Home Affairs. And so this limitation on their rights needs to be justified by the state. And our contention is that it's unjustifiable on a number of grounds.
And in the case of Dennis Tatenda Chadya, he had an application for permanent residence, which was also denied, I believe, but that he then married a South African and now has spousal visa, but still can't be admitted to the profession, is employed as a legal advisor. What is the distinction here? If he's allowed to be a legal advisor, why is he not able to practice law?
I think you've hit the nail on the head that non-citizens are allowed to fit into all the other facets of the legal industry. They're allowed to be candidate attorneys, they're allowed to be legal advisors, they're allowed to be legal researchers. But when it comes to that licensing criteria, to allow them to be fully practicing advocates or attorneys, they're then barred. And it goes again to speak to the rationality question of how are these people able to contribute in a myriad of other ways and are barred at this last step of admission. I think essentially that's the contention that we're making.
Okay, so what is the next step? When do you expect, or at least have some definitive response from the Constitutional Court?
The matter is actually before the Pretoria High Court. The High Court is allowed to decide on constitutional matters, and where it declares any legislation unconstitutional, this must then be confirmed by the Constitutional Court. So the case was only recently launched. We're waiting to hear back from the Minister of Justice and the Legal Practice Council. It may still be some time before we get those responses and we get our day in court.
So what are you saying, that should that fail, will you take it as far as the Apex Court?
Indeed, I think that where a constitutional matter needs to be determined, our goal is to take the case all the way. Ultimately, this is an issue of fairness and rationality. And as I said, the Constitutional Court itself has decided a number of cases on the right to equality. We have a rich jurisprudence on the right to equality in this country. And we just want that same law to be applicable to these citizens, to these individuals, to allow them to practice their trade.
Well, thank you so much for speaking to us. Muchengeti Hwacha is the Executive Director of Asylum Seeker, Refugee and Migrant Coalition.